Even though the President is obliged to receive advice from the Judicial Service Commission, itself made up of the presidential appointees when appointing judges of the High Court, or is obligated to receive advice from the Chief Justice when appointing justices of the Court of Appeal, recent revelations made in Parliament have shown a scandalous disregard for the Constitution when appointing judges and justices. Thus, because of the long shadow of the presidential power, we have persons appointed justices of the Court of Appeal who do not qualify for appointment as resident magistrates. Similarly, I repeat, because of the long shadow of presidential power, we have persons appointed justices of the Court of Appeal who do not qualify for appointment as resident magistrates. Similarly, we have persons appointed judges of the High Court who have previously been caught with their ethical pants down, or who cannot string together two sentences in straight English, or who are too ill to serve in any capacity, judicial or otherwise, or who are tired, having served the country in other capacities, to be of any use as judges. In addition, we have contract judges when our Constitution provides for tenured judges. Indeed, we have persons appointed judges and justices who may have committed serious crimes, such as bribery and the forgery of personal records, in order to qualify for appointment. In short, we have on the bench many persons who should never have gone anywhere near our judges' chambers. These facts have been fairly well known within the government, the judiciary itself, and I dare say, within the bar. They have been the subject of considerable soul searching and hand-wringing within the corridors of judicial and executive power at the highest levels. They are the subject of very lurid and juicy gossip by lawyers and laymen alike. Yet, no one, not even this distinguished gathering, has dared to raise their voice in public. No one has stood up to be counted. We all fear to be targeted by the cabal that has now filled our courts wearing judicial robes. Yet, as William Rivers Pitt, the American author, has argued, silence is the greatest sedition. Our silence in the face of the greatest attack on the integrity of our judiciary is our complicity in the crimes of the cabal. To use the term of criminal law, by our silence, we are aiding and abetting those who are hell-bent to destroy our courts by filling them with judicial misfits. 16 years ago, the former Chief Justice Barnabas Samata warned us against aiding the judicature's grave diggers through our obsessive demands for compliance with the rules of procedure. The greatest danger now is not the obsession with technicalities. Our aid to the judicature's grave diggers now consists in our silence, our fear to speak out, and thereby risk our petty privileges, our cowardice in the face of the flooding of our judiciary with judicial mediocrity. Though, as I have stated, the issues raised here are fairly well known and have been in any case in the public domain most recently, Professor Wambali has, perhaps not without fear of the dire consequences, devoted only one sentence to the scandal involving judicial appointments in his one paragraph dedicated to the independence of the judiciary. So, ladies and gentlemen, what should be done? Without jealousy. The problems raised in my paper demand urgent answers. Their solution can no longer be evaded or postponed. Hiding in the small-mindedness of our little law chambers and hoping that someone else will clean the orgium stables of our constitutional mess can no longer suffice. As individual citizens or the professionals that we take ourselves to be, we must take a stand. We should demand an immediate resignation. We should demand accountability from everybody involved in this sordid saga. We should demand an immediate resignation or expulsion of all judges and justices who have been appointed and continue to serve contrary to the Constitution. We should independent and transparent investigation of why things were allowed to go so horribly wrong and for so long. Distinguished members, I have before me a court of appeal, a decision of the Court of Appeal that was rendered only 4 days ago. And what it has to say about our judges is shocking. As a high-level task force appointed in 2008 to inquire into this mess found out, and this is what a task force involving the President's office, high officials of the judiciary and the Attorney General's chambers, and this is what they found out regarding these matters. And I quote from the report: "These judges perform the duties of a judge contrary to the Constitution. Hence, all duties they have previously performed and currently continue to perform have no legal validity whatsoever. It is as if the said duties were performed by any other employee who does not hold the office of judge." End of quote. The task force, comprising of senior, as I've said, of senior officials from the President's office, the Attorney General's office, and the judiciary, recommended that the President be advised, quote unquote, to immediately resign the contracts involving those judges because they have serious consequences to society, and for the appointment of new judges to take their place. 4 years have passed since that recommendation. Nothing has been done to date. The integrity of our judiciary and the future